Hello everyone, this is Tom Fox. I'd like to welcome you to episode 141 of the FCPA Compliance and Ethics Report. Today I go a little bit different direction in honor of Pi Day, March 3rd, March 14 in the year 2015. I talk about the beauty and symmetry of Pi and how that relates to an anti-bribery and anti-corruption compliance program. I talk through some of the elements of a compliance program and try to demonstrate how they all interrelate. I go in a little bit different direction today. It comes in at a little over 21 minutes, and I hope you enjoy it. Thank you very much for listening. Hello everyone, this is Tom Fox, and I'd like to welcome you to the special Pi episode of the FCPA Compliance and Ethics Report. In honor of Pi Day, March 14, 03-1415 of 2015. I'm recording a special Pi episode. It'll be released next week, but in honor of Pi Day, I hope you will all have a wonderful piece of pie. Think about the beauty of mathematics. For those of us who are challenged to add 2 plus 2 with a calculator, it doesn't mean it's not a beautiful science. So with that short introduction, what I would like to talk about is the not only, of course, Pi Day, but how the symmetry of Pi and the beauty of Pi can inform your overall compliance regime. One of the things that I've been thinking about lately is the respective role of various agencies, organizations, and individuals in anti-corruption and anti-bribery. Obviously, the FCPA is a congressionally enacted law which is enforced by 2 U.S. government agencies, the Department of Justice on the criminal side and the Securities and Exchange Commission on the civil side. And it's really interesting that the agencies, both the Department of Justice and the SEC, get regularly criticized from both the left wing and the right wing for their FCPA enforcement. Sort of the right wing says that, bribery happens everywhere. We shouldn't be prosecuting American companies. Who are we to, in a derivative of that is, who are we to actually prosecute companies subject to the act, but may not be American-based companies? Doesn't that mean there'll be a tit-for-tat retaliation in trade sanctions or other prosecutions? The left wing, or at least another school of thought, says that corporations get off too lightly, and there's really no significant enforcement effort because in the current era of deferred prosecution and non-prosecution agreements, there's no incentive for corporations to comply with the FCPA because an enforcement action is simply a cost of doing business. Now, if you're Avon and you had a $750 million cost of doing business, that would certainly be a very expensive cost of doing business. I would advocate that that is certainly something that companies should consider, but nevertheless, many commentators point to DPAs and NPAs as perverting the system, in large part because corporations are not sufficiently punished, and that the U.S. Department of Justice should go after more individuals. Of course, if they go after more individuals, that will put more people in jail, and corporations will pay less money in fines and penalties. But that part is rarely talked about when commentators talk about the need for more individual prosecutions. Nevertheless, what I would like to focus on Pi Day is another prong of FCPA compliance enforcement, and that's the persons who the law applies to. Since we now know from Mitt Romney that corporations are people, and of course the U.S. Supreme Court has affirmed Mr. Romney's pronouncement in the Citizens United case, U.S. corporations are subject to the act. Any foreign subsidiary of a U.S. corporation is subject to the act. Any U.S. citizen is subject to the act, and that's anywhere in the world. Any non-U.S. citizen who works for a U.S. corporation or for a foreign subsidiary of a U.S. corporation is subject to the act. And finally, any U.S. subsidiary of a foreign corporation is subject to the act. That leaves aside the issue of territorial jurisdiction, where if part of a bribery scheme occurs in the United States where money is wired to or through the United States, or emails are sent through the United States, could also create jurisdiction. So the point of that is it's about as broad as it can get. So with that, those are the people who are subject to the act. But I want to focus on Pi Day is what is the responsibility of corporations and persons subject to the act to follow the FCPA? Should there be greater incentivization for people to comply with the FCPA by either adding a compliance defense, watering it down, making it easier for corporations to escape liability through the corrupt actions of their employees or their subsidiaries? Is that really needed? Further, what is the responsibility of corporations and individuals now subject to the FCPA to comply with the law? Well, I would argue that if a law is in place, society has made the determination that the law should be in place, and by society I mean in the U.S. that would be through our elected governmental officials. I think the decision has been made that, at least in 1977 it was made, that bribery and corruption by U.S. companies of foreign government officials outside the United States is antithetical to the interests of the United States. And with that determination and enactment of that thought into law, that companies and individuals subject to the FCPA should follow it. It's really no different than, or rather, are there costs to that? Well, absolutely. Anytime you change the rules or stop someone from doing something, there is a potential cost. But if you think about it in terms of speeding, society has made a determination through its representatives that driving above a certain speed is not safe. Is there a cost? Certainly. I don't get there as quickly. But the rules are there. The incentive for me to comply with that law is, one, the law's in place. Two, it makes driving safer. And three, potential enforcement in the form of a speeding ticket. So that, in my mind, is pretty similar to what a corporation's responsibility is under the FCPA. The claims that corporations need incentives to follow a law that's in place that you and I have to follow seems to me to be really sorely misplaced, because there's already incentives. That's why I pointed out the Avon case with potentially $750 million in pre-investigation costs, fines and penalties, and post-investigation costs, or what the FCPA professor would call the three buckets of FCPA costs. Further, the notion of pi and the symmetry of pi can really help explain your compliance with the FCPA, because it's all in an integrated manner. So for your compliance program with your company, clearly it all starts with the top. And I was really reminded of that recently by the ongoing scandal of HSBC, and particularly the comments of its current CEO, Stuart Gulliver. For those who are unaware, HSBC a couple of years ago signed a huge deferred prosecution agreement over $1 billion for money laundering violations, promising, of course, never to do it again, put a robust compliance program in place, spent a lot of money, ramped up their compliance program. But it turns out that during the time, they were laundering money in their Swiss subsidiary. And even more interesting, it turns out that the CEO, Mr. Gulliver, was using the same scheme to hide bonus payments he received from HSBC, except that he was laundering it through a Panamanian company. All very interesting. Not clear that not suggesting Mr. Gulliver broke any laws, but certainly he was hiding money, and has admitted he was hiding money, and has admitted he did hide the money, so his coworkers would not know how much money he made. And whether he was trying to hide that from the British government, that's another question, but that's open for another day. But the more interesting part of Mr. Gulliver's recent comments about his role in his corporation really help crystallize some of my thinking about Pi Day and FCPA compliance. One of the things that Mr. Gulliver has said publicly is, quote, "Can I know what every one of 257,000 people is doing?" That's the number of employees who work at HSBC. Now, you would think with a CEO who had signed one of the largest DPAs in the history of the world ever would want to admit publicly that either he doesn't care enough to find out, or his company is simply too big to obey the laws that you and I have to follow. Really wouldn't want to say that in public, but it points to the role of management. And is something too big to manage? If it is too big to manage, does that mean it's too big to know whether it's engaging in illegal acts? If it's too big to know whether it's engaging in illegal acts, should it be broken up into smaller units? Is that something that is a good management practice, a good company practice? Is that something society wants to have going forward? Do you need to be so big that you really have no clue that you are not, no clue what people in subsidiaries across the globe are doing? And it also points to, I think, Mr. Gulliver missing a key point of what the role of senior management is in a compliance program. It's not the responsibility of every leader or leaders to know what every employee is doing. That's not it. But by using a combination of the right structure, the latest technology, but most importantly, imbuing within your company a correct culture and reinforcing regular communications about your culture across the corporation, that's the role of senior management. And Mr. Gulliver doesn't seem to recognize that he has a role, and he has a role to start the process, but the process has to be more than simply starting it. You simply can't say, I told them what to do and they didn't do it. You've got to use technology to incentivize employees. You've got to use technologies to monitor employees. You're not ever going to be able to assure yourself that 257,000 employees are doing the right things, but it is your responsibility to ensure that they're moving in a right direction. If you think about the 10 hallmarks of an effective compliance program, which was in the SEC and DOJ jointly published 2012 FCPA guidance, the way the 10 hallmarks worked, I would suggest to you, is shows or is informed by the symmetry of the number pi. And that symmetry is as follows. Think through each one of those elements. I spoke at length about Mr. Gulliver and tone at the top, but it just starts there. You've got to have a risk assessment to know what your highest risks are. You've got to have policies and procedures in place to do the detailed implementation of the more widely noted statements of senior management, or certainly more general statements that we're going to do business in the right way. How do you implement that kind of statement? You implement it through policies and procedures. And then you train employees on it. You make sure that they understand it. You give them the tools to understand that. That could be a live training. That could be an online training. But you make sure you communicate that. But communication is more than just training. It's ongoing. And that's where it's important to have a senior authority over compliance. That's the chief compliance officer with a reporting line to the board of directors, so that the chief compliance officer has the authority to enact, implement, develop, and oversee your anti-corruption and anti-bribery compliance programs. So you see the integrated nature of what the 10 hallmarks are, but it's even more than that, because it's incentivizing. You really do have to put incentives in place to make sure that people will follow your program, and you've got to have disincentives, so sticks and carrots. But why can't you provide incentives? Why can't that be a part of a discretionary bonus, year-end or annual bonus? Why can't that be a part of your overall evaluation? The answer is there's no reason why it cannot be. It's simply because companies do not make the decision to assess on that basis. So the ongoing communication is reinforced by your actions going forward. The next step is monitoring. And frankly, if your company is too big to monitor, it's too big. And by using a combination of technology and personal resources, I think that you can monitor your compliance program going forward. A monitor program does not mean you have someone read every email or review every email, but you can certainly set broad parameters around that. You can set parameters about where emails are going. Are people using personal email accounts? I've written at length about Catella software and how they can map out where emails are going. But you can do transaction monitoring. You can put software in place to allow you to determine if a red flag is raised. If a red flag is raised, it may warrant further investigation. So monitoring is a key component, but monitoring is really a good business practice. You really should know what's going on with your employees. You should be able to know what is being booked as revenue. You should be able to account for your assets, and you should know where your money is going and paid out. Obviously, with anti-corruption programs, third parties are recognized as a huge risk, and this is where a risk assessment ties into managing your third parties to determine what the appropriate level of risk management should be around that. And finally, and this is probably the subject of a complete other podcast, is mergers and acquisitions. You certainly don't want to buy an FCPA violation, and many commentators on both sides criticize the department along these lines, but I find their criticism solely misplaced because the Department of Justice has made clear, at least since 2008 and probably long before that, on what they expect in the area of M&A. And it started in 2008 with the Halliburton opinion release, which put very aggressive deadlines in a post-acquisition acquisition integration and investigation, because Halliburton, for legal reasons, was not able to do pre-acquisition due diligence sufficient to be able to make a determination of the company they were looking at. But since that time, those very aggressive guidelines have been modified in enforcement actions and indeed in the FCPA guidance. As recently as 3 months ago, we had the Department of Justice in Opinion Release 1402 lay out what it expected for pre-acquisition due diligence. They had talked about this in the guidance. It was reinforced in this opinion release. So the notion of buying an FCPA violation, springing liability, or somehow that corporations cannot protect themselves really is pretty disingenuous at this point. So the interplay or overlay of a compliance program is an integrated series of steps, but you really shouldn't take each step separately because they do overlay each other. Just as technology provides a mechanism for oversight, technology can be a part of your communications. You can have online training, you can have monthly compliance reminders. From the Morgan Stanley declination, one of the most interesting things that Morgan Stanley did that the DOJ specifically pointed out was in 7 years they sent out 35 email compliance reminders. I would ask you to consider, what's the cost of an email compliance reminder? And is 5 a year over 7 years really going to institute compliance fatigue? I would say no. So there's lots of techniques that you can use through technology, or technology can be used by you to not only communicate the message, but monitor going forward. I've written extensively on internal controls, and internal controls are simply a system put in place that allows you to a structure to maintain control of compliance and anti-compliance and anti-bribery. One of the best explanations I know of the structural component of internal controls was put forth by my good friend Aaron Murphy, who's currently a partner at Foley and Lardner. And he says internal controls are policies, procedures, monitoring, and training that are designed to ensure company assets are properly and with proper approval, properly used, with proper approval, and transactions are properly recorded in the books and records. While it's theoretically possible to have good controls but bad books and records, it's very rare. Generally, the two go in hand. hand in hand. Where there are record-keeping violations, there's an internal controls failure, usually because the records would have been accurate had the controls been adequate. So internal controls are also a part of this. My point to all this on Pi Day is your compliance program is not a standalone, one part solves all. It is an integrated approach to complying with the FCPA. I find it to be straightforward. It's laid out in the 10 hallmarks of an effective compliance program. Our UK cousins have 6 principles of adequate procedures of anti-corruption compliance. The OECD has 13 good practices. The U.S. sentencing guidelines exist, and there are even others. Stephen Martin and Paul McNulty at Baker & McKinsey have the 5 elements of an effective compliance program. So there are formats that you can go to and structures that are out there in the public domain. They're relatively straightforward. I would even say they're simple. They may not be easy to implement, but they're out there for your use. So for companies who say, we can't comply with the FCPA, the information is out there. And I would ask you to consider, what is the role of a corporation in complying with any law? Should there be greater incentives? Should you be given some sort of carte blanche if you have a paper program in place? The key is it effective in complying with what the law requires? And unless you do compliance, I don't think it will be. So, like I said when I started this podcast, I wanted to do something a little bit different today in honor of Pi Day and get on a Howard Sklar inspired mini rant, if that's the right phrase. But I hope you had a good piece of pie on Pi Day. And if you have any questions on any of this, please check out my blog, the FCPA Compliance and Ethics blog. You can also check out other podcasts at the FCPA Compliance and Ethics Report, or you can email me at tfox@tfoxlaw.com. This is Tom Fox, and once again, wishing you a happy Pi Day. Thank you.